requirements in law, the board in the past enacted these regulations to define what the board considered substantially related to the profession. So where you see things that are not underlined, that's existing standards. Where you see things that are underlined or struck, those are the things that we're proposing to change as a result of this legislation. So the first change is to add the term professional misconduct to the regulation. AB 2138 will authorize this board to deny a license if the applicant was subjected to formal discipline by a licensing board located in California or outside of California for substantially related professional misconduct. So in recognition of that new authority, we've added the term professional misconduct throughout the regulations in front of you. We've added a new subdivision B here because Assembly Bill 2138 requires the board to revise its existing criteria to add these new standards. So you'll see here in subdivision B, the nature and gravity of the offense, the number of years elapsed since the date of the offense, and the nature and duties of a contractor or home improvement salesperson must be considered before determining something related to the profession. So that's been added to the regulation. We have added new language to amendment to subdivision C1 here. You'll see that we've added the words or other state or federal laws governing contractors or home improvement salespersons. So in adding this language, we'd recognize that a violation of the laws or regulations governing the contractor's license in another state or any laws governing the license, federal laws governing the license, would be considered related to the practice, as these issues can highlight competence problems, problems with professional judgment, and the ability to practice the profession with safety to the public. Do you have any questions about these changes to Section 868? Any questions about the reg in general? Okay, on to 868.1, sorry. So the next page, when Assembly Bill 2138 becomes effective next July, for most convictions, the board will lose jurisdiction to use them as a basis for denial once we hit the 7-year mark. Felonies, misdemeanors, all of it, most of it will go away after 7 years. However, there is an exception to the rule, which is for crimes, felony financial crimes that are directly and adversely related to the profession that are classified as a felony. And it's what this regulation is intending to do, is to define what the board considers directly and adversely related to the fiduciary qualifications, functions, or duties of the profession, because that's the new standard that this bill enacts. So in developing the methodology for selecting which crimes the board thinks are related, there really is no legal precedent for this. So what we did is, and you should have this with you, a spreadsheet here. It looks like this. I don't know if you see that. Okay, so what we had staff do is to develop the methodology was to have the licensing staff compile a list of all financial crimes for which the board has denied licensure over the past 5 years. So the spreadsheet will show you all those different crimes. And what we've done is we've taken those crimes, broken down the elements of those crimes, and then put them in this regulation. So because we don't have any kind of legal precedent for it, we're using a factual basis to set forth what we think is related to the profession. And so you'll see in the spreadsheet and in the regulation, the baseline standard is if it involves dishonesty, fraud, deceit, or theft that resulted in direct financial benefit to the applicant or another person or entity, direct financial harm to another person or entity, or an attempt to obtain direct financial benefit or cause direct financial harm, then it would be considered related. And then the list that follows are things like identity theft, crimes involving the acquisition or provision of false, altered, forged, counterfeit, or fraudulent documents, stolen property, embezzlement, and so forth, and any attempts or conspiracies to commit those crimes. So does anyone have any questions about that? Go ahead.
Chrissy, this is financial crimes, right?
Right.
There still are the crimes of attacking someone in their home or I mean, what kind of physical harm things when someone gets access to someone's home?
Right. If you go back to the substantial relationship criteria, you'll notice that one of the descriptions of crimes that your board thinks are related are crimes or acts involving physical violence against persons. So it's already your standard, but what AB 2138 does is no matter whether it's that kind of crime or any other, 7 years is the limit you have to use it as a basis for denial. So the only exception is for felony financial crimes that are directly and adversely related to the contracting or home improvement salesperson professions. So
if they're repeated
there's only you can go beyond 7 years. Well, AB 2138, there's 3 categories of exception. So 7 years is your limit for most misdemeanor and felony crimes. The exceptions are for serious felony. That would include robbery, rape, murder, that sort of thing. Directly and financially related crimes, which we've defined here. And the third category is felony habitual sex offenders. So your misdemeanor sex offender crimes will wash out after 7 years. All misdemeanors will wash after 7 years. We won't be able to use them to deny someone a license under this new law. But you do have the ability in regulation to define the exception to the 7-year rule for financial crimes that are felonies. So these are the types of crimes that the board staff identified that you have denied people in the past for. So that's how we came up with this list. Of course, if you don't agree with anything in here, we can take it out and alter it. But that was the factual basis we used. But there's nothing we can do about what the bill does to limit your jurisdiction. We can only use the regulatory process to expand on the authority that the legislature's given you to these types of crims.
Right, but you're saying those 3 areas are exempt
are
from the bill.
The 7-year washout period, yes, are serious felonies, but
right.
Serious felonies, this habitual sex offender felonies, and directly and financially related felonies. All misdemeanors, no matter what kind, will wash out after 7 years.
And Christy, that's even if there's a pattern. It
doesn't matter.
Doesn't matter. Yeah.
Yeah.
Was there any board comment? Additional? Any public comment?
I'm not done. Sorry. I wish I were. So there's 5 proposals. We've gone through 2. So the third one is your rehabilitation criteria. So when we're looking at whether to deny an application, it's a 2-step process. The first one is the crime or act related to the profession? That's the substantial relationship criteria we just went through. The second one is, even if there's a basis for denial or discipline, the person may be so rehabilitated that it doesn't matter and you don't use it as a basis for denial or discipline because they're fully rehabilitated and safe to practice. Because the role here is not just to deny people for an issue, it's to look into their past and the future and see how they're doing and see whether they qualify for a license or should be disciplined. So that's what the rehabilitation regulations do. And bear with me because this is a really complicated one because your process is a little different than some of the other boards. And so with the rehabilitation criteria, we have 2 options for you. The first one is, and it's based on this criteria. Beginning in July, AB 2138 will require you to evaluate whether the applicant or licensee has made a showing of rehabilitation. If either of the following are met, the applicant or licensee has completed the criminal sentence at issue without a violation of parole or probation, or a board in applying its criteria for rehabilitation finds the applicant is rehabilitated. So it's a bit circular. We're using the regs here to try to flesh out what you mean by that. The first option for implementation, if you look at this page at the top, it says, "Well, the Board of Registers shall consider whether the applicant, licensee, or registrant made a showing of rehabilitation is presently eligible or fit for a license if the applicant, licensee, or registrant completed the criminal sentence at issue without a violation of parole or probation. In making this determination, the board will look at these criteria." So you'll see there are 5 criteria listed here. And the staff would use those criteria to determine whether the parole or probation was sufficient to rehabilitate that person alone. So you would use these criteria to evaluate that parole or probation to see if they've made a showing of rehabilitation. And if you don't feel like they have, then you go on to the next set of criteria starting in sub B. So that's option 1. Option 2, if we can flip really quickly to page 7, thank you. Page 7, that option is more of a bright line standard and presumption of a showing of rehabilitation. So what would happen here is that the Board of Registrar would find that they are rehabilitated if they've completed parole or probation. So it's very straightforward. There'd be less for the staff to analyze and investigate. It would be the cheaper alternative, but it would, would remove somewhat your discretion, because basically you would just say, if they've completed parole or probation, we're good. We don't need to look any further to see if they're rehabilitated. So that's option 2. Yes,
So are we ready to talk about option 1 or option 2?
not yet. Real quick. So those are that's the main difference between option 1 and option 2. So if after we get through that part, whichever one you pick, the second half of the regulation had to be significantly changed. And the reason is because of that 7-year washout rule with AB 2138. Your current regulations puts benchmarks in place. And what those benchmarks do is they tell people if they have a particular type of crime, when the board might consider them rehabilitated. And so right now, for felonies, the board's regulations say that there will be a presumption you're rehabilitated after 7 years have passed and no additional offenses, criminal activity, or misconduct has occurred. For misdemeanors, it's 3 years. And then for all other conduct, because remember, it's not just crimes that we deny or discipline for, it's for other standards, acts or omissions, things like willful and deliberate disregard of building laws of the state would be an example of an act that you would discipline for or deny for. So there's 3 categories in your rehabilitation regulation. 7 years, 3 years, and 3 years are the current standards. But because we cannot treat applicants and licensees the same way anymore after AB 2138, because remember, after 7 years, we lose jurisdiction over most crimes, we had to separate out the applicants from the licensees in those benchmarks and create new ones. So the second half of the regulations for both options, they say the same thing, are that for felony crimes, the minimum benchmark for considering where they might be rehabilitated for an applicant, if we look at, so any felony convictions within 7 years of an applicant's applying, the benchmark would be 5 years, right? Because remember, after 7, we lose jurisdiction. So 5 years for applicant felonies. And then those other felonies that I discussed that that take us out of the 7-year period, which is the sex offender, the directly adversely related, and the felony financial crimes and the serious felonies. Those 3 categories, remember, we don't lose jurisdiction after 7 years. So the staff are proposing to keep the 7-year felony standard in place for those types of applicants. So those are the 2 primary changes. Everything else, the staff are recommending we retain 7 years for licensees for felonies, 3 years for misdemeanors, whether you're an applicant or a licensee, and then 3 years for discipline based on professional misconduct, acts, or omissions. So if you have any questions, I totally understand, because it took us a while to pull everything apart and put them in new categories, because like I said, that line has shifted for when we lose jurisdiction. So we had to recalculate those benchmarks. And the staff feel that those benchmarks are important to keep in there, because people will call up and say, hey, I was convicted of a crime. This is the type of crime I have. What does it look like for me? Do you think I'll be able to get a license? And the staff are able to point to this regulation and say, this is what we use. Now that number can go up or down based on mitigating and aggravating circumstances. So it's a flexible regulation, but the staff do like those benchmarks. So we're looking at, again, 7 years for applicants, 5 years for applicants that have any kind of criminal conviction. and 7 years for the ones that have the serious felonies and the accepted felonies. And then everything else is kind of looking the same. Any questions? I know it's confusing. I
Well,
tried to simplify
Well,
it.
somewhat, yeah, somewhat, but
I know.
I want to talk about the option one, option two, because
Okay.
it sounds to me
Mhm.
like the option one is more subjective and the option two is more objective.
Correct.
And I think because we don't want staff exposed, neither do we want the board exposed. If we have an objective standard that says, once you've completed your parole and you've completed your sentence, whatever it is, and you're on the other side of that, then we can make a decision, not,
Well,
we're going to think about whether you're rehabilitated ahead of this. And I'm just concerned about somebody getting a license, going into someone's home, doing the same thing
right,
again
right.
earlier
So-
than their parole or sentence,
Well-
which might expose.
Yeah, no, I mean, you'd still have the ability to deny if they hadn't completed their parole
No, I
or
understand
probation. But the bright line standard would mean if they passed parole or probation, then they would get an unrestricted license under option two. Option one, you would kind of evaluate based on the type, because parole and probation don't all look the same. So you would have the ability to look at those probation terms to see if, like, for instance, they got a domestic violence conviction. Did they take anger management classes as part of their parole or probation terms? Did they have an alcohol problem and they went to AA or they went through a rehabilitation program? That
So
kind
you're
of
right,
thing.
it is confusing because I didn't see it that way. If the reality is option one allows you to.
It
say-
does.
It allows you to judge on the crime and on the completion.
Yeah,
And that.
you would examine under option one, there's 5 criteria, and the staff would use the nature and gravity of the crimes, the lengths of the applicable parole or probation periods, the extent to which the parole or probation period was shortened or lengthened, and the reasons the periods were modified, the terms or conditions of probation or parole, and the extent to which they bear on the rehabilitation, like we just discussed, and the extent to which the terms or conditions of parole or probation were modified and the reasons for modification. So
All
it
right.
would be more, you're right, a subjective, there would need to be investigation. It's up to you whether you think that's important or not.
So there's always a question about with the subjective work that the staff would have to do in determining whether to, grant a license.
Right.
How much more time would that take?
Correct.
Also, they're making judgment calls on things that they would have to either research or ask about. So,
Correct, yes.
I mean, and quite frankly, what the staff, what
Justin might be able to answer.
okay.
Comment on that, 'cause this is extremely important. When we talk about rehabilitation, we're talking about financial crimes. In construction, you have contractors that commit felonies, diversion of construction funds, grand theft. That's what we're talking about here. We need to be able to consider that before licensing somebody. We're not going to be doing anything we don't already do today. We already do that. But I would just ask that you not take that away from the staff, the ability to look at that.
Okay. Any other questions
So
on?
option one is closest to what we're doing already.
Yeah, I mean, it would be a little more work, I think, than what we do standard, but I mean, and Justin might be able to.
Well, we
Pipe in.
just don't want to be licensing people that owe consumers tens of thousands of dollars. We have to be able to look at that. We can't just simply say because the court said they're off probation or parole, they're suitable for licensure when they haven't proven rehabilitation. We need to be able to consider.
Okay, anyone else?
Just in an effort to expedite, I mean, the staff recommendation is the proposed regulation, which everybody's had a chance to look at.
Okay,
And option one is the case by case. And this is to go into rulemaking. So there's going to be plenty of opportunities to really look and digest each one of these. So with that as a background, I'd make a motion to adopt the staff recommendation.
there's 3 motions.
Time out, we have 3 votes, unfortunately we have to do 2, so.
Yeah,
So you can make the first one, which is, the first staff recommendation is to approve the proposed regulatory text and changes for section 869 that allows the staff engage in a case-by-case determination about the rehabilitation of each
And I would make the motion to adopt the 3 staff recommendations on page 88 in one fell swoop.
I mean, it's up to you if you want to do all 3 at once, but let's just make sure everybody's read the 3 and knows what they are.
So I just read the first one, 869 that allows sorry, case by case determination. The second staff recommendation is to approve the proposed regulatory text and changes to sections 868, 868.1, 869.5, and 869.9. The third staff recommendation is to direct staff to submit all approved text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. If no adverse comments are received, authorize the registrar to take all necessary steps to initiate the rulemaking process, making any non-substantive changes to the package and set the matter for hearing. So are those, you want to make all 3 of those? I did. Okay. Do we have a second? Okay. Felice, do you know who the second is? Okay. Is there any public comment on these?
Yes, actually, I was planning on making a comment this morning, and I missed my opportunity. But it's probably better related to what we're discussing now. My name is Jody Costello, and I'm the founder of ContractorsFromHell.com and the Home Remodeling Boot Camp for Women. And I launched my site as a result of a home remodeling nightmare that I experienced about 18 years ago, and where I found myself in the fight of my life to receive justice. And the good news is that I did win my case and I did receive justice. But since then, I've been advocating for consumers and sharing those hard-learned lessons through my site and helping them to avoid the common pitfalls in renovating and hiring contractors, because the dangers out there are very real for consumers. They tend to be very trusting, and that's what gets them into trouble. So I simply want to remind you all of the mission statement that drives this board, which is in part to protect consumers by regulating the construction industry for the greater good of the public. And that you move forward with decisions today and beyond today, that you are mindful of that statement and that those decisions made are in direct alignment with that mission statement. And that's really all I had to say. I think it's important. You had a lot of comments this morning, and it was something that I'm really not familiar with, but I'm glad that I have this opportunity to do that and to always make sure that when you are making decisions in favor of the consumer, of course it has to be fair and balanced, but that you consider the risks that are involved when you make those decisions on regulations. Thank you.
Thank you. Please.
Marla Richardson.
Aye.
Kevin Avenese. Frank Altamura.
Yes.
Augie Beltran.
Aye.
Linda Clifford.
Aye.
David Delatorre.
Abstain.
Dave Diaz.
Yes.
Susan Granzella. Joan Hancock. Mike Layden. Frank Shetter.
Aye.
Johnny Simpson. Nancy Springer.
Yes.
Motion passes.
Felice, can you do me a favor? I believe that I've already gone over and got a motion for the strategic plan. Can you check so I don't have to repeat myself, please? I thought I did too. Okay, Tanya. Okay. Moving on to the closed session. Is there anyone in here that does not need to be in here? Okay, I'm sorry. We're now to agenda item H and I, which is our closed session pursuant to section 11126E of the Government Code. The board will move into a closed session to receive advice from legal counsel in the following 2 matters. First, Tasha Padfield versus Department of Consumer Affairs Contractors License Board et al., U.S. District Court Central District of California, case number 218 CV 8358 CJC. And the second matter is URS Corporation versus Register of Contractors, California Contractor State License Board, et al., Orange County Superior Court, case number 30/2019, 0153135 CUWMCJC. At this time, members of the public will need to leave the room. You will be allowed to return when we are ready to go back into open session. We are now going to go back into open session. Our next agenda item is J, Administrative Program Update. Since board members have had the opportunity to review these materials, I'd like to ask if there's any comments or questions on items J1, J2, or J3. Board members? Is there any public comment?
Do you have your abbreviations?
Linda, would you like to?
I can do this whenever you're ready.
We're ready.
Sorry. Hi, my name is Sarah Kane, and I'm a legal volunteer representing Elder Law and Advocacy. Elder Law and Advocacy provides free legal advice and Medicare counseling for seniors living in San Diego and Imperial counties. The organization would like to thank and express its appreciation to this board for taking an interest in and responding to complaints about unscrupulous contractors who are selling property assessed clean energy, PACE, products to senior homeowners in our area. We will continue to direct client victims to the board to file complaints, and we look forward to continuing our mutual work to protect victims from losing their money or homes because of PACE. If anyone on this board would like more information on this issue, please contact Carolyn Riley, Supervising Attorney and Executive Director at 858-565-1392. Thank you.
Thank you, Linda, for sharing that for her. Next, we will be going on to agenda item K, licensing, and I would like to turn that over to Committee Chair Frank Schetter.
Thank you. The licensing program update begins on page 113 and contains the statistics through January 31, 2019. In the interest of time, I will not ask Justin to summarize the report, but I did want to mention that CSLB has seen a 22% increase in the original applications. All application processing units are caught up and are between 2 and 3 weeks in processing times. Do the board members have any comments? Seeing none. Does anyone from the public have comments? Seeing none. We'll move on to testing program update. The testing program update is on page 131 of your packet. Again, in the interest of time, I will not ask Justin to summarize the report. Do the board members have any comments? Seeing none. Does anyone from the public have comments? Seeing none. We're moving on. Final remarks. The licensing committee will be held in Sacramento Thursday, May 2nd, 2019 in the morning. An agenda for the meeting will be available in the coming weeks. And the licensing report.
Thank you. Moving on to agenda item L, enforcement. Committee Chair Kevin Albanese.
The enforcement program starts at page 139. Any questions from the board? Any questions from public? That concludes the enforcement section.
Nicely done.
See how this one goes. Agenda item M, public affairs. We're going to turn it over to Joan Hancock.
Starts on page 151 of the packet. I have no preliminary comments. Are there any public attending that want to make comments? Board members, any comments, any brief comments you'd like to make? All right, moving to M1. Yes, go ahead.
I'm sorry. I just think it's important that I bring this up, and that is the Find My License contractor. So I've been getting some feedback on that, good feedback, and I just wanted to pass that along. People like that. They do realize that it gives quite a bit, but they like that tool to be able to use that. So they just asked if we can fine tune it a little bit more. And I said that we were trying to look at that. So thank you. Good job.
I have to backtrack because there was a comment I wanted to make, and that was to staff. What a great job you did in Sunset Review coverage. Thank you for keeping us tuned in when we were
Yes.
tuning out there. So that was amazing. That's it. Okay, on to the Public Affairs Program update. Our only agenda item this afternoon is M1, and Rick will work on that. You're not going to do that? Rick has done his, any board, any public members have comments? And board members, any comments on the program update in your packet? Madam Chair, that concludes the public affairs report.
Thank you, Joan. So it says adjournment on page 183. I don't have a 183 in my packet, so that's going to be all the board's business for today. And thank you guys so much for
Still moved.
everything.
Still
Good,
moved.
motion, approved. Felice, please.
Who was the second?
Linda.
I made the motion. I don't know who.
I'll
Oh.
second it. Second.
Okay. Marla Richardson,
Hi.
Kevin Evanese, Frank Altamira,
Hi.
Augie Beltran,
Dawn.
Linda Clifford,
A.
David Latorre is absent. Dave Diaz is absent. Susan Granzella,
Yes.
Joan Hancock,
Aye.
Mark Layden, Frank Shetter,
Aye.
Johnny Simpson, Nancy Springer.
Yes.
Motion passes.
Get home safely. Meeting adjourned.